Hello, everyone, and welcome to today's Fenwick Elliott webinar. My name is Stacey Sinclair. I'm a partner here at Fenwick Elliott, and we are delighted to welcome you back today. We had a short break over the summer, and to kick off our autumn series, we are pleased to be back to you and to bring you our next adjudication update. Our last adjudication update was back in April. And welcome back, Adele. Thank you for the last one and to this one. And so today's session is aiming to bring you up to speed on the case law and the developments in construction adjudication in the UK since then. And to take us through some of those important cases backed by popular demand, we have both Daniel Churcher, a barrister of Four Pump Court, who specializes in construction, engineering, energy law, as well as professional negligence and insurance. And Adele, of course, Adele Parsons of Fenwick Elliott, one of our senior associates here, who also specializes in construction and energy law and all forms of dispute resolution. Both Adele and Daniel are experts and well experienced in adjudication and adjudication enforcements. We're very pleased to have them again today. Thank you both. So before I hand over, just a few admin points. For those of you who join us regularly, thank you for being back with us. And as a reminder, you'll find the toolbar on the right-hand side of your screen. We would be delighted if you would pop in questions into the questions bar, and we will put just a couple of those to Daniel and Adele at the end of the session. Everyone is on mute, and we will put those questions anonymously to Dan and Adele, so please do write in. Rest assured, a copy of the slides will be available on our website in due course after this session, so I'm sure you'll find those helpful. And with that, Dan and Adele, I shall leave it with you. Thank you very much.
Thanks, Stacey. Okay, so welcome everybody. I'm going to be kicking off today. The first case I'm going to be discussing today is the Court of Appeal case in Sudlow Limited and Global Estates. Now, I discussed the first instance judgment in the last adjudication update, as it was then, as it is now, an important case for those of us unfortunate enough to be involved in serial adjudications, as it provides clarity and establishes some key guidance as to when a dispute referred in an adjudication is the same or substantially the same dispute as one determined previously, and when a subsequent adjudicator is bound by the findings of his or her predecessor. So firstly, going back to the basics. Now, it's well established that a dispute cannot be referred to adjudication where it is the same or substantially the same as one which has been previously referred and decided upon. And essentially, if it can be shown that a dispute is indeed the same or substantially the same, then the later adjudicator must resign if asked to reopen that dispute. What comes down to being the same or substantially the same is a matter of fact and degree, which will obviously vary on a case-by-case basis. Now, this doesn't mean that the earlier determination of a dispute is a closed book and that the parties are bound by the decision of the earlier adjudication forever. Rather, the adjudicator's decision is considered to be interim binding, meaning it's binding until it's finally determined either by litigation, arbitration, or indeed the parties' agreement. Now, the reason for ensuring that the adjudicator's decision remains interim binding and that it cannot be reopened by a further adjudicator basically comes down to the key drivers of construction adjudication, these being speed and cost. Now, as to cost, the courts are clear that adjudication should be a means of meeting the legitimate cash flow requirements of contractors and their subcontractors. Similarly, the courts are clear that when it comes to speed, that adjudication is intended to provide a speedy and proportionate temporary decision of disputes arising under construction contracts without the need for protracted and often very expensive arbitration or litigation. It's apparent, therefore, that there is very much a pay now, argue later mindset. However, while this seems simple enough, this principle of speed and cost effectiveness does not always reconcile with serial adjudications and parties seemingly wanting to have a further bite of the cherry. Indeed, as the Court of Appeal in Sudlow's recognised, which we'll come on to, it's certainly harder to adhere to a principle of pay now, argue later when you're constantly arguing now. So against that background, let's remind ourselves of the facts in Sudlows. So here, Sudlows is an M&E fit-out contractor, and they were engaged by Global Switch under a JCT design and build in respect of significant electrical works at Global's London premises. Now, this particular dispute concerned a section of the works that involved building a new private electricity substation at the site. To do that, new high voltage cables had to be installed, which had to be brought in from another part of the site. And to do this, Global, who were responsible for the enabling works, had to install ductwork under a main road that divided the site. Now, unfortunately, those enabling works were subject to delay, and shortly afterwards, there was also an issue with one of the cables being damaged, allegedly by Global's defective ductwork. This ultimately resulted in the cabling works being removed from Sudlow's scope and given to another contractor, which thereafter led to Sudlow's, again allegedly, refusing to terminate, connect and energise the cables. Sudlow's therefore commenced what was then the parties' fifth adjudication, seeking an extension of time on grounds that the events relating to the damaged cables were relevant events under the contract. In summary, the fifth adjudicator decided that Sudlow's was indeed entitled to an EOT as the issue of defective ducting and the delays caused by taking the cable works out of Sudlow's scope amounted to relevant events as defined, and that Global was ultimately culpable for the delays caused. So following practical completion of the work, and based on the fifth adjudicator's decision, Sudlow's commenced a sixth adjudication in which it sought a further EOT based on the same relevant events that the fifth adjudicator had considered. Sudlow's, some would say reasonably, submitted that the adjudication 6 was a natural consequence of the fifth adjudicator's decision to grant an EOT, and that therefore the sixth adjudicator was bound by the fifth adjudicator's decision in respect of the cabling relevant events, effectively meaning that the sixth adjudicator was bound to grant Sudlow's the EOT it claimed. In response, Global claimed that the fifth adjudicator's findings on the relevant events formed part of his reasoning, but were not part of his actual decision, i.e. it wasn't an essential component. Therefore, the sixth adjudicator was not bound by the fifth adjudicator's previous findings in respect of relevant events. Global went on further to say that it was entitled to challenge and put in further evidence before the sixth adjudicator on the relevant events, which it was not able to put before the fifth adjudicator. From the outset of the sixth adjudication, there was an issue as to how far the adjudicator was bound by the decision of the fifth, with the result that the sixth adjudicator actually asked the parties to agree that in the event he decided he was bound by the decision in adjudication 5, he should nevertheless go on to consider the position and make alternative findings as if he were not so bound, i.e. he should put forward an alternative decision. It's important to note that while this course of action was agreed, permission was not given, however, for the sixth adjudicator, in Sudlow's words, as cited there on the slide, to open up and redecide what had already been decided by the fifth adjudicator. Consequently, the sixth adjudicator primarily decided that he was bound by the decision of adjudication 5 as regards the cabling relevant events, and therefore bound to grant the further EOT sought by Sudlow's. In making this decision, he noted that the relevant events were indeed an essential component of the EOT decision in the fifth adjudication. And then the adjudicator went on to set out what became known as his alternative decision, i.e. the position as if he were wrong to restrict his own jurisdiction and was not bound by the decision of the fifth adjudicator. Now on this, he decided that the events in question were not relevant events, and therefore he wouldn't award Sudlow's any EOT, rather he would award Global some 209,000 in delay-related damages. So what we have here, therefore, are two very different results depending on whether the adjudicator is bound by the fifth adjudication. So following the sixth adjudicator's primary decision in Sudlow's favour, Global sought a declaration in the Technology and Construction Court that the sixth adjudicator's primary decision should not be enforced, as he had actually breached the rules of natural justice. They argued that by determining he was bound by the fifth adjudicator's decision, he had taken too narrow a view of his own jurisdiction. Now, As a result of this, Global argued that it was the adjudicator's alternative decision, unsurprisingly, seeing as that was the one in Global's favour, that should be enforced. The court agreed with Global on the basis that the disputes in Adjudication 5 and 6 were not the same or substantially the same. For example, the court considered it significant that the EOTs sought in the 5th and 6th adjudication related to different time periods, and that the dispute in relation to the further EOT sought in the 6th adjudication involved new circumstances and new materials being placed before the adjudicator, which were not placed before the 5th. Some would say this is an odd conclusion, as what constitutes a relevant event and the responsibility for that event under a contract is arguably an essential component of any EOT decision. So therefore, I mean, in my mind there's clearly some overlap. So convinced that the 6th adjudicator was indeed bound by the decision in Adjudication 5, Sudlow sought to appeal the TCC's decision in the Court of Appeal. The leading judgment in the Court of Appeal, which was formally handed down in July this year, was given by Lord Justice Coulson, and in short, the court overturned the TCC judgment, finding that the 6th adjudicator had been correct to decide that he was bound by the decision of the 5th adjudicator. The reason for this is that, in actual fact, the dispute in Adjudication 5 was the same or substantially the same as the dispute referred to in Adjudication 6. Namely, the question to be answered was which of the parties was contractually responsible for the cabling and ductwork issues. The binding element of the decision in Adjudication 5 was not just the award of some 480 days extension of time, but that Global was contractually responsible for the cabling and ductwork issues. Indeed, the court found that any other result would be fundamentally inconsistent with the binding decision of the 5th adjudicator, resulting in two diametrically opposed results a few months apart, which was certainly not in accordance with the principles of construction adjudication, rather it being a sign that something had gone wrong with the process. The court was clear, however, that if Global did want to challenge the earlier decision, it of course could, and it had every right to do so, but it had to go to the court or arbitration. Now, in reaching this decision, the Court of Appeal helpfully set out 4 guidelines applicable to serial adjudications and what to consider when determining whether a dispute referred to an adjudicator is the same or substantially the same. And turning to that, so the first of these is essentially premised on common sense and a recognition that the purpose of construction adjudication, i.e. speed and cost, is not easy to reconcile with serial adjudications, but should be followed wherever possible. Indeed, if the parties to a construction contract do engage in serial adjudications and then inevitably get drawn into debates about whether a particular dispute has already been decided, the need for speed and the importance of at least temporary finality mean that the adjudicator, and if necessary the court on enforcement, should be encouraged to give a robust and common sense answer to the issue. Now, the court was clearly unimpressed with anything which resembled a pleading point or a legal technicality, reiterating that this whole question should not be a complex question of interpretation of documents and citation of authority, but rather a question of common sense. The second factor raised was the need to look at what the adjudicator actually decided to see if that second adjudicator had impinged on the earlier decision. Now, of course, it can be relevant to consider submissions such as the adjudication notice and the referral notice, but what really matters for the purpose of the Construction Act and the scheme is to look at what it was in reality that the adjudicator decided, as it is this which cannot be re-adjudicated. And this again comes back to this overarching principle of having a more sort of common sense, robust approach to this question. The third principle is the need for flexibility. So while parties and adjudicators alike should not seek to re-adjudicate a claim or defence on which they have unequivocally lost, they should also ensure that what is essentially a new claim or new defence is not shut out. And this is where that test of fact and degree that I mentioned earlier comes into play. Finally, the court said that one way of at least testing whether the correct approach has been adopted is to consider whether, if the second adjudication is allowed to continue, it would or might lead to a result which is fundamentally incompatible with the result in the first adjudication. For example, if in that second adjudication, one or more or other of the parties is asking the adjudicator to do something that's diametrically opposed to that which the first adjudicator decided, then that may be an indication that what they are seeking to do is impermissible. So lots of helpful guidance there. Ultimately, I think the Court of Appeal's judgment is actually very helpful for those of us in the midst of or facing serial adjudications. Hopefully, the guidance provided will go some way to deter negative forms of serial adjudication. For example, losing parties sometimes seek to re-adjudicate a claim which they have previously lost by making minor cosmetic changes and presenting it as a different claim, even though in substance it simply isn't. And in my view, that's both unnecessarily expensive for both parties and is also unfair because it can lead to never-ending disputes in which parties seek to have another bite of the cherry, which certainly doesn't accord with these principles of speed and cost inherent to construction adjudication. Another point to remember that I've flagged there on the slide is that what is the same or substantially the same is a matter of fairness, common sense, fact and degree, and should not involve an overly technical interpretation or forensic fact-finding. Finally, what was also very clear from the court's judgment is that they will be slow to interfere with an adjudicator's finding unless it can conclude the adjudicator was clearly wrong. And indeed, Lord Justice Coulson was clear when he said that in serial adjudications, the policing of this sort of debate is primarily left to the adjudicators themselves. The court should only intervene when something has gone clearly wrong in the later adjudicator's decision. And in my view, that is not the case here. So, sticking with the theme of natural justice, I thought I would then discuss the case of Home Group versus MPS. This dispute concerned high volume but low value emergency and maintenance works that MPS had undertaken for Home Group under a JCT measured term contract. Excuse me. In short, a prior adjudication between the parties had determined that MPS had repudiated the contract. HG therefore sought to recover the costs of the repudiation through a second adjudication. Now, HG's referral notice for the second adjudication was very, very large. It contained a large amount of materials which covered thousands of individual orders, and also included a quantum report which ran to some 155 pages long. Now, on the report, it is important to note that this was actually provided in draft to the other side about a month before the referral was served. And it was actually also essentially the same report as one relied on previously between the parties. So when it came to timetable, MPS were probably quite shocked to discover that they were only given 19 days to respond to the referral, which they kept to. When it came to decision time, the adjudicator awarded HD some 6.5 million, which MPS then refused to pay. So this led HG to seek some reinforcement of the decision, which MPS sought to resist on the basis that the procedure giving rise to the decision was so unfair that it constituted a breach of natural justice, that they had not had enough time to review the complex and voluminous materials included in the referral, and that there was no clear procedure by which the complex issues could be addressed within the prescribed time frame. The court simply rejected this argument. It upheld the adjudicator's award on the basis that the adjudication system is there to find quick answers rather than the right answers. The mere fact that an adjudication contains a significant volume of material is not of itself sufficient to establish a breach of natural justice. Indeed, previous case law has demonstrated that such arguments would rarely succeed. The court also referred back to the principle of broad justice, which was laid out by Coulson and Amett Group versus Thames Water Limited, to reiterate that ordinarily the inherent complexity of material will not be sufficient to produce a breach, and that the key question when demonstrating a breach of natural justice is whether the adjudicator can appreciate the issues and submissions so as to do broad justice between the parties. So how does the adjudicator appreciate the issues? On this, the court found that it was not necessary to seek a wholly unrealistic and disproportionate situation in which an adjudicator has access to the details of each and every work order. With that in mind, sampling approaches will usually furnish the adjudicator with sufficient information. And on this, the court was very, very clear that such sampling assessments are a matter of substantive determination for the adjudicator, basically meaning that even if they pursued an erroneous approach to tackling the data or information before them, this is merely an error, like any other error, which will not ordinarily affect enforcement. And this again comes back to a principle well known that adjudicators are indeed permitted to make mistakes. Considering the foregoing, the court found that while a combination of time constraint and complexity could in principle produce a breach of natural justice, the facts of this particular case simply didn't support MSS's claim for such a breach. To succeed, it would be necessary to meet that test of materiality I've mentioned, meaning that an adjudication decision will not be enforced if it's reached in breach of natural justice, that it is so material that it has led to a material difference in the outcome. The mere fact that HG had more time than MPS to prepare its submissions was not sufficiently material. Indeed, on the facts, it appears that MPS actually were able to and did properly and thoroughly engage in the substance of the claim. And actually, they enjoyed relatively significant success in undermining a number of high-value aspects of that claim. It was true that the response was less comprehensive than would be expected in litigation or arbitration. However, the court noted that's plainly not the test. Besides, the facts of the case indicated that MPS's defence was always going to be difficult to maintain. Further, the court noted that MPS were actually not expected to wait until the referral landed to begin producing their response. For example, it transpired that MPS had failed to appoint an expert until 17 days after the draft expert report was first issued. The court's view was therefore that it had plenty of time to deal with this. So ultimately, the judgment is an important reminder to parties to not simply assume they will be given additional time to prepare submissions just because they are served with a large volume of papers or that the substance of the claim is complex. Similarly, you can't plead ignorance to claims where it's apparent that you and the other side are both aware of a dispute prior to it being referred, and indeed this goes back to the rule that parties are to ensure a dispute has crystallised between them before referring that dispute to adjudication. That's me finished now, so I'm going to hand you over to Dan. Thanks, Dan.
Thank you very much, Adele. Good afternoon, adjudication fans and possibly pro wrestling fans as well. I give that slightly odd introduction because the first thing I'm going to talk to you about today is the recent four-pump court SmackDown tag team title fight between Alex Hickey KC and Met Mesfin in the red corner, Sean Brannigan KC and Simon Hale in the blue corner. I am referring, of course, to the recent bitterly fought dispute between FK Construction and ISG. And I know it was bitterly fought because my room in Chambers is next door to Alex Hickey's room. And on a fairly regular basis, he has been coming into my room with words to the effect of, you'll never guess what that charming gentleman, Sean Brannigan, has done now. I paraphrase only slightly. So the background to this dispute is that ISG retained FK to carry out roofing and cladding works on two projects, although we're principally concerned with one of them. The first project is this one, Project Barbary. And by the time that this all came before the court, there had been 4 adjudication decisions in relation to Project Barbary. The first one, the Scheuer decision, this was in relation to FK's application for payment 14, £1.5 million, no valid pay less notice from ISG, so ISG must pay in full. Second decision, the Wood decision, 27th of February 2023, FK's application 16 for 1.6 million. Again, no valid pay less notice. ISG must pay in full. Third decision, the Riband decision, 7th of March 2023. FK's application 13, 1.55, no valid pay less notice. ISG must pay in full if the Wood decision is not satisfied. That's an important fact to bear in mind. So the Riband decision was expressly conditional on the Wood decision not being paid. Now, clearly ISG's contracts manager was having a very bad day with his pay less notices. So what ISG then did was they ran off to Mr. Malloy in April 2023 and did a true value assessment. And the outcome of that was that there was a net balance due to FK of 0.9 million. So that true value decision went quite a long way to knocking down these smash and grab sums that FK had successfully obtained in an adjudication decision. So the other project, Project Triathlon, 3 adjudication decisions on this one. First, the A. Burley decision. ISG was entitled to terminate and liable to pay and FK was liable to pay ISG 760,000. The Riband's Triathlon decision, ISG was entitled to a further payment from FK, £105,000 in this instance. And then the third decision was the Jensen decision, which was FK was entitled to payment of 801,000 from ISG. So for those of you not tapping away on your calculators, the net position as at this point is that there is quite a large sum owing to FK, albeit reduced slightly from the smash and grab by virtue of Matt Malloy's true value decision. And there is a slightly smaller sum owing to ISG on Triathlon. So what happens? FK, of course, go off to the TCC and try and enforce the Wood decision. ISG doesn't raise any substantive points against the enforceability of the Wood decision, but they do say, well, we want to set off the sum that is in effect due back to us in respect to the Malloy decision. So we only want to pay what Matt Malloy says we're supposed to pay. And we also want to set off the net sum of £66,000 odd that is due to ISG in respect of the Triathlon decisions. Comes before Joanna Smith, and she says, well, the starting point, as we all know, is that adjudication decisions ought to be enforced, and generally no set-off is allowed. That comes from Mr. Justice Jackson's judgment, as he then was in Interserve way back in 2006. And in that case, and subsequently, there have been found to be 3 exceptions to this. First, where there's a contractual right of set-off, which is compliant with the policy of the 1996 Act. Those sorts of clauses are going to be rare because in general, such clauses need to be read so far as possible so that they're consistent with the Act. So in general, if possible, they'll be read so that they don't allow set-off between or against an adjudication decision. The second exception, where it follows logically from the decision itself that a set-off is allowed. And then last, subject to the court's discretion, where there are 2 valid and enforceable decisions involving the same parties. And it's that third decision that that third exception that ISG is trying to rely on. So when does that exception bite? That is addressed by Mr. Justice Aikenhead in HS Works. He says there are 3 conditions, not 4. The court must determine first that both decisions are valid. The court must also determine that both decisions are capable of being enforced. And then, provided that the parties have both brought proceedings to enforce their decisions, the court should do its best to give effect to both. And the rationale for that last point is that if there are 2 valid and enforceable decisions, then usually there will not be a valid or logical basis in which to give primacy to one decision over the other. Now, what Mrs. Justice Smith said in this case was that ISG failed at every hurdle. The court was not in a position to assess the validity or enforceability of the Malloy decision, which had come out pretty recently before the parties ended up in court before Mrs. Justice Smith. And also there were no extant proceedings in respect to the Malloy decision. No steps yet had been taken to enforce that decision. So no set off for ISG, round one to Team Hickey. The parties end up back in court not much later. On 14th June 2023, Adrian Williamson KC hands down an unreported judgment. And in that judgment, he deals with two Part 8 proceedings that that ISG has launched. One is in respect of the triathlon issues, which we don't need to deal with. I should have mentioned, actually, in relation to the Smith judgment, the triathlon set-off issues seem to have just withered away. It looks like everyone sort of ran out of steam and sort of accepted the way the wind was blowing, and then the triathlon issues just didn't really get much airtime. So there was no set-off in respect of that triathlon sum either. Again, in these Part 8 proceedings, the triathlon bit is not all that interesting. We're more interested in the Barbary bit. And what FK was, or what ISG was saying in those Part 8 proceedings, was that the Scheuer decision, which you'll remember was the first smash and grab decision in relation to Project Barbary, had fallen into error. And ISG was seeking a final determination on a Part 8 basis of this point. In the contract, payment applications, notices, etc. were allowed to be late. But if they were late, what happened was all of the subsequent dates would move back in tandem. And what Scheuer had said was, well, that's fine then, notwithstanding that FK's fourth payment application was late, it is saved by this sort of shunting provision. Therefore, it is a notice that has been given in accordance with the contract for the purposes of section 110B4 of the 1996 Act. Therefore, it is treated as a payee's notice, and ISG needed to put in a payment notice or a pay less notice in order to avoid paying the sum demanded. And what Williamson said in those Part 8 proceedings was, no, Scheuer has got this wrong. Payment application 14 might be valid, but it is not in accordance with the contract, therefore not a payee's notice under section under the 1996 Act. So round two to Team Brannigan. The Scheuer decision is a dead duck. So ISG then runs off to the TCC, and it is now trying to enforce the Malloy decision. And you'll recall that in front of Joanna Smith, ISG was not allowed to enforce the Malloy decision. It hadn't had proceedings up and running in respect to the Malloy decision, and the Malloy decision was effectively ignored for the purposes of those proceedings. But what ISG also does, in a move that got Alex Hickey very upset, was when this came before the court, ISG sought to amend its claim. And what it said was, well, actually the Wood decision was reached on the same contractual basis as the Scheuer decision, i.e. this point about the shunting dates and validity of a late payment application. So if Scheuer goes, Wood goes too, is what ISG said. And ISG said that means what we're now looking to recover is not just the difference between Wood's smash and grab decision and Malloy's true value decision. Actually, we want to recover the whole of the Wood payment, which I think was about 1.6 million, something like that. So FK say in response to that, well, that's fine, but what you really need to do is go away and try and correct that overpayment in the next payment cycle, rather than deal with it now. We can deal with that point relatively shortly. If you go back and look at Joanna Smith's judgment from the first round, she does quite a good job of going through the authorities on when a right to repayment arises. And there is the Supreme Court decision of, I think it's Aspect Construction or Aspect Contracts, which says that when an adjudicator's decision is overturned, by a court or in arbitration, an immediate right as some form of restitution or implied term, whatever you want to call it, but an immediate right to repayment arises. So applying that principle here, no, ISG doesn't need to wait for the next payment cycle. It can undo the financial effects of the adjudication decision immediately. Point two, this was an argument that the Wood decision survived on grounds that weren't affected by the overturning of the Scheuer decision. Williamson wasn't particularly impressed by that, and that really comes down to construing the Wood decision, which is not something that we've got time to do today. Third, and most interestingly, FK said, well, okay, fine if the Wood decision goes, but doesn't that mean that the Ribans decision kicks in? And you'll recall the point I highlighted to you, that the Ribans decision or enforceability of the Ribans decision was conditional on the Wood decision not being enforceable. So FK said, fine, Wood is gone, Ribans springs into life, and we'll have the Ribans money instead. Thank you very much. What does Adrian Williamson say to that? He says, no, if monies are paid pursuant to a decision and that decision is knocked down, monies must be immediately repaid. The same sort of jurisprudence that we were discussing just now in relation to the Supreme Court in aspect contracts. And it's not open to FK to go fishing around for other decisions pursuant to which you might hang on to that money. And you might notice that what's really going on here is sort of a mirror image of the attempted set-off in the Smith proceedings. We have an immediate right to repayment on the part of ISG because the Wood decision has been overturned. And what FK is effectively trying to do is set off against that repayment right the sums due in respect of the Ribans decision. And although it wasn't analysed in exactly the same way, actually applying the Aikenhead principles, you can see why the Ribans decision would not be enforced, because there weren't any extant proceedings in respect of the Ribans decision. The court wasn't being asked to opine on the enforceability of the Ribans decision. All the court had in front of it was the fact that the Wood decision had been overturned and the clear jurisprudence that says where an adjudication decision has been overturned, any money that has flowed under that decision goes back the other way. So matters have really come full circle, but that's no consolation to Alex, who loses round 3. I suppose the only consolation is that no one beat each other round the head with a folding chair, so far as I know. Right, so that is the end of the big Chambers derby that I wanted to tell you about. I'm going to carry on with the theme of payment disputes, which are almost an ubiquitous feature of these adjudication updates, starting with Lidl Great Britain and Closed Circuit Cooling Limited. So this is quite an important decision for anyone who is drafting payment provisions in construction contracts. And I don't know about you, I've seen 1 or 2 contracts where in order to try and preempt any difficulties with smash and grab type scenarios, employers write into their contracts that the final date for payment doesn't come around until the contractor issues a VAT invoice or something similar, right? So you go through your payment application, payment notice, pay less notice, you've got your final date for payment, but that is postponed until, let's say, 7 days after a VAT invoice is issued by the receiving party. Obvious advantage to that for employers, it gives them just that little bit more time, one extra bit of paper to get their act in order. That's exactly what Lidl tried to do here, and that's what they put in their contract. They lost a smash and grab adjudication. They issued Part 8 proceedings looking for a final determination of the VAT invoice point, i.e. whether they were allowed to rely on this VAT invoice point. And they said because of the VAT invoice point, no VAT invoice was ever issued, therefore the final date for payment has not yet arrived. And so the issue for the court was whether it's permissible to link a final date for payment to an event rather than a particular date under section 1101B of the 1996 Act. Now, this had been given some airtime previously in a case called Rochford Construction by Cockerell J. And the obiter decision in that case was no, the final date for payment has to be linked to the due date, not some other intervening event. And His Honour Judge Davies, in this case, agreed, looking at the wording of section 1101B. If we go back, I'm not sure I can go back. I'm not going to try it because I don't want to make a mess of the slides. But you'll recall that the last, excuse me, the last bit of 1101B says that the parties are free to agree the period between the due dates and the final date for payment. And what His Honour Judge Davies says was contrast that with section 109(2), which says that parties are free to agree the amounts of payments, the intervals between payments, and the circumstances in which payments fall due. And the judge said there was very clearly a difference in wording between that section and 110(1)B, which is much narrower. And what that pointed to, the judge says, I think probably rightly, is that Parliament in section 110(1)B was giving parties freedom to agree a period of time, but not anything more complicated than that, and not giving the parties the freedom to inject another piece of paper into the process. So you can agree as long a period as you like, perhaps, but what you can't do is link the final date for payment to some further event or invoice or anything like that. Right, last case I'm going to talk about, and then we'll have a bit of time for questions. Henry Construction Projects Limited and Allufix. So what had happened here, Allufix had made a payment application, Henry Construction issued a pay less notice. Allufix didn't much like that pay less notice, so it commenced an adjudication, smash and grab adjudication, disputing the validity of the notice. Before a decision came out on that first adjudication, Henry Construction commenced their own true value adjudication. That went before Mr. Malloy, whose name has appeared, I think, now 3 times in this talk. And what Malloy did, very sensibly, is he said, well, look, I know that there is a smash and grab adjudication ongoing. And I also know that it is alleged in that smash and grab adjudication that you, Henry Construction, have not complied with your immediate payment obligation in respect of Allufix's application. And I also know, because the TCC has been telling me uphill and down dale for the last couple of years, that if you haven't discharged your immediate payment application, you can't commence a true value adjudication. So he says, what I'm going to do is I'm going to proceed with this adjudication until a decision comes out in adjudication 1, which says, yes, you have to pay and your pay less notice is invalid. Because until that time, says Mr. Malloy, I don't think there is an immediate payment application. Allufix does win adjudication 1, and Malloy then stays adjudication 2 on the basis that an immediate payment obligation has now arisen and he can't proceed. Henry Construction then does the honourable thing and pays the sums due in respect of adjudication 1. Mr. Malloy lifts the stay on adjudication 2. They get to the end of that true value, and he finds that Allufix has been substantially overpaid. So Henry Construction trots off to the TCC, tries to enforce the Malloy decision and recover the overpayment. And the question is whether Matt Malloy had jurisdiction to carry on with his true value adjudication. The principles we all know by now, per Mrs. Justice O'Farrell in Bexheat, where a party is required to pay the notified sum by reason of its failure to issue a valid payment notice or pay less notice, such party is entitled to embark upon a true value adjudication in respect of that sum, but only after it has complied with its immediate payment obligation. Henry Construction says, well, fine, but there was a genuine dispute here as to whether there was any immediate payment obligation. So it's perfectly legitimate for us to have started a true value while that question was still sort of floating around in the air unanswered. The court is having none of it. the court says no, your immediate payment obligation arises as a result of the contract, or in default of the contract, it arises as a result of the provisions of the scheme which are incorporated in the contract. The adjudicator's award or decision effectively confirms that that immediate payment obligation exists, but it doesn't bring it into existence. Therefore, at the time you started your true value, there was an outstanding immediate payment obligation. Therefore, Mr. Malloy had no jurisdiction in adjudication 2. The court then enters into a bit of a discussion about what this means for employers and how difficult it will make life for employers for fairly obvious reasons. And I think possibly just to sort of throw employers a bone, the last line in the judgment is this: not quite shutting the door. Overall, in my view, the outcome in this case, while not closing the door on commencing a TVA prior to the outcome of an SGA, and later relying upon the outcome, ought to discourage such a course in areas of spurious SGA disputes, but not deter those who have a sufficient level of confidence that any dispute resolved, any dispute raised should result in a finding of no immediate payment obligation having been established. So what does that actually mean? What the court seems to be saying is that if you have missed your pay less notice, and your contractor has stuck in a smash and grab adjudication notice, you are at liberty to start your true value adjudication, but you effectively do it at risk, because unless you subsequently establish that there was no immediate payment obligation, i.e. you win your smash and grab, then that true value adjudication should never have been started. But that's not really very useful, is it? Because if you win your smash and grab, then you don't need your true value, because you don't have to pay anything. So why would you commence a true value, the best outcome of which is going to be you've got to pay something, if the true value is meaningless unless you've already defeated the smash and grab and therefore have to say nothing? So I'm not quite convinced that this has been fully thought through. There's a second problem that arises, which is what is an adjudicator supposed to do in those circumstances? If you are Matt Malloy in the position that he was in this case, you know that there's a smash and grab that's been started. You know that if that smash and grab succeeds, you have no jurisdiction. What do? Do you just carry on, potentially exposing both parties to irrecoverable costs, including your own? Or do you resign, which is what has been suggested in other authorities, is what adjudicators ought to do in these circumstances? It's all just a bit unclear. I think it remains to be seen exactly what best practice is for adjudicators in those circumstances. But in any event, it does seem pretty clear now that the circumstances in which you can bring a true value are getting narrower and narrower with every one of these adjudication updates that we give. So those are my cases. If I hand back to Stacey, we might have some questions.
Thank you, Dan, Adele, and all I can say is, wow, you definitely have not disappointed us and the audience since your last adjudication update. In the time allowable, I think you have clearly and concisely covered everything from serial adjudications, natural justice, set-off, payment disputes, a reminder of the fundamental principles of construction adjudication, and have also managed to give us the play-by-play exciting recount of the 4-pump court pro wrestling smackdown. I'm not sure what else we can deliver to the audience next. But thank you so much for the past 15 minutes. We do have time for a couple of questions. Let's go to you, Adele, first, so maybe Dan can have a to see what's coming in. Adele, maybe start with, what can you do if an adjudicator makes a clear error? How easy is it to rectify that?
I suppose the first thing to ask is, what type of mistake or error are we talking about? If it's a clerical typographical error, then the slip rule applies, which most people will know about, which essentially means that adjudicator can amend their decision within 5 days of him or her issuing it. subject to comments from the parties, which in my experience actually are invited quite often when that decision lands. If we're talking, however, about an error that goes to, say, the heart of a dispute, for example, an error of law or calculation, then unfortunately, I think I sort of touched upon it in the seminar, there's probably very little that can be done prior to taking the dispute all the way to litigation or arbitration for it to be finally determined. I mean, it comes back to this principle that, quite frankly, adjudicators are allowed to make mistakes, which again is essentially founded on this principle of pay now, argue later, and is why, unfortunately, adjudication sometimes does get labelled as being rough justice. Saying that, though, there are caveats to that. If it can be shown that that error is actually them exceeding their jurisdiction, or that error amounts to a breach of natural justice, then certainly I think you've got more scope with that. It also helps as well. Certainly, there's been sort of a flurry of TCC cases where people have sought to jump in almost before an enforcement and make a Part 8 application seeking a declaration that part of a decision, and I hasten to add, a part of this decision being easily severable from the rest, which would remain enforced, seeking a declaration as to that part, i.e. getting that part finally determined. But I mean, long answer short, it's hard, and the court does, the court will be sort of very reluctant to, let you challenge a mistake unless by way of final determination.
Thanks, Adele. And maybe I'll one more question whilst you're here, obviously. Someone's asked, how common and how successful are natural justice, natural breaches challenges?
I mean, it's a pretty high hurdle to jump. I think it's pretty well accepted that there is limited scope when it comes to challenging an adjudication decision based on natural justice. Essentially, you have to demonstrate that either you weren't informed of allegations and had a chance to, or an opportunity to answer those allegations, or that your case, the person hearing your case, is biased and impartial. As I said, that's some pretty hefty obstacles to overcome there, and again links back again to what I've talked about quite a lot today, about this almost inbuilt risk of unfairness that can be built into the adjudication process in order to give a speedy and cost-effective review. And I think as a result of that, even though something may seem unfair, the case that I touched upon with MPS, the court won't really accept arguments that there's been a breach of natural justice, for example, because a party has been ambushed at Christmas, or they don't have time, or where the dispute is considered to be sort of too complex for adjudication. So it's difficult, certainly in my experience. Great, thanks, Adele.
We've had a couple of questions in about smash and grab adjudications, always very topical. So Dan, maybe the first one here is, if I've lost a smash and grab adjudication, but I think the true value is much lower, and I want to be in a position to set off against the smash and grab, what should I do?
I mean, that's a question that I get asked quite frequently, as I'm sure Adele and Stacey do as well, and it's always gives a bit of a sinking feeling when a client asks that question, because this is one area of law where I'm sure lots of people in the audience know or feel themselves, where client expectations differ quite a lot from what the law actually allows, right? And I think a lot of clients, when you tell them how smash and grabs work and how true values work and all that jurisdiction and jurisprudence that goes with it, they really struggle to get their heads around it, for understandable reasons. I think that the direction of travel in the TCC over the last couple of years is very, very clear, and the avenues to starting a true value and setting off are being fully explored by all sorts of different people and generally being found to go nowhere. I think the only area where there is still room for exploration, and it slightly surprises me that this doesn't happen more often, is what happens when you're dealing with different payment cycles, right? And what I mean by that is if you've got a payment application in respect of, let's say, payment cycle 10, and you don't get a pay less notice and you start your smash and grab, in the meantime, payment cycle 11 comes round, and on that occasion, the employer does put their pay less notice in on time, and actually they decide to start a true value on that payment cycle, not on 10. And let's imagine that actually these adjudications end up happening at the same time. And let's imagine that the enforcement proceedings in respect of each one are issued at the same time. And so the court ends up in a situation where it has smash and grab on 10, true value on 11, and employer saying, I want to only pay what's on the true value. It's not obvious to me that that wouldn't be allowed. And in Bexheat, the true value and the smash and grab were both in respect of the same payment cycle. And if you apply the Aikenhead principles that we looked at right at the beginning of my slides, you've got two apparently enforceable decisions, and you've got them both in front of the court at the same time, and you've got extant proceedings in respect of both, where they're both trying to be enforced. I don't know what the court would do with that, and I'm not suggesting anyone run off and try it. I think if you want a proper answer from me on whether it's a good idea or not, then you'll have to instruct me and pay me. But I think of all of the possible avenues that there were to this sort of two-step smash and grab true value dance that people want to try and do, I think that might be the only one that still remains open.
Fantastic, thanks, Dan. I think we can squeeze in one more. I'm not sure if you've had a chance to look at it yet on smash and grabs. We've had someone ask, Dan, regarding the final case discussed, Malloy's jurisdiction in adjudication 2. Why could Malloy's decision not just be enforceable once the party who lost adjudication 1 has made the payment they were obligated to make from the smash and grab?
There's a short answer to that, which is because the adjudication was started before they'd paid the sum. So the jurisprudence from Bexheat is you cannot start your true value adjudication until you have discharged your immediate payment obligation. So it didn't matter. Essentially what the court is saying is you can't come along and save your adjudication, your true value adjudication, by paying the sum halfway through. Malloy either had jurisdiction from the beginning or he had no jurisdiction at all.
Thank you, Dan. Perfect. With that, it seems we've come to the hour. So if I may, before we leave you, if I could just give everyone a heads up on our next webinar next month on the 19th of October, where we have Fenwick Elliott's Ben Smith and 39 Essex Chambers barrister Samantha Jones, who will join us to discuss the Building Safety Act and navigating the latest developments. We, of course, have a number of regimes and new regulations coming into force in a couple of days now, and they will take us through those latest developments, what we should watch out for, and what will we be seeing possibly. So I hope you can join us in October. That QR code on the screen there should get you to the registration page, as well as some other of our newsletters are set out there below if you are interested. But Dan, Adele, thank you so much today for taking us through so clearly and concisely, as I had said, all of those cases. And a huge thank you to our audience for joining us again today. We hope you are well, and we hope to see you again in the near future. So thank you, everyone. Hope you have a great rest of the week.
Bye.
Thanks for having me, Stacey. Thanks very much.